Nupur, let me know once we are live.
We are live, ma'am, actually.
Yeah, good evening, everyone. I welcome you all on behalf of YOSI Legal Core Team and YOSI Core Team to this wonderful evening. This webinar series was started in August 2022 with the aim that we should educate the young ophthalmologists regarding the medico-legal aspects related to ophthalmology. And we have covered very interesting topics so far. To name consent, Consumer Protection Act, record keeping, indemnity insurance, how to respond to a legal notice, medico-legal issues regarding cluster tasks and cluster endophthalmitis, telemedicine and its medico-legal aspects, cataract surgery and related medico-legal aspects, ROP and its related medico-legal aspects, issuing medical certificates, intravitreal anti-VEGF, billing related medical legal aspects in ophthalmology, medical legal issues related to mass cataract surgeries in camps, medical legal aspects related to refractive surgeries, NMC guidelines for ophthalmologists, medical legal issues related to violence against doctors and healthcare professionals. And we had very interesting topic last session, which was on live surgeries and it related medical legal aspect. And I'm very happy to say that we are in our 18th session, wherein we are going to discuss criminal and civil responsibility of the hospital as per the new criminal law. So we will just get introduced to our panelist once again. We have with us Dr. Anand Deshpande, sir. He is director and eye surgeon at Guru Prasad Netra Rugnalaya at Aurangabad. He is chairman of Indian Medico-Legal Consulting Services Private Limited. He is co-chairman of Legal Committee of AIOS. He is faculty of law and visiting professor to Symbiosis Law College in Pune. He is National Law University Aurangabad faculty management services at BAMU Aurangabad. And he has written various books related to medical legal aspects in ophthalmology, to name a few. So thank you, Anand Deshpande, sir, for being with us always. Next, we have with us Dr. Manish Machwe, sir. He is not an ophthalmologist. He is an obstetrician and gynecologic endoscopic surgeon based in Pune. He is past chairperson of Ethics and Medical Legal Committee of Federation of Obstetric and Gynecological Societies of India, and he is MC member of Indian Association of Gynec Endoscopists. Manish sir has been with us for 2 previous sessions, and he has been a very guiding force for us. So thank you, Dr. Manish, for being with us for this session. We have with us Dr. Manoj Mathur, sir. He is senior consultant in glaucoma and comprehensive ophthalmology at Swaroop Eye Center in Hyderabad. He is presently the honorary treasurer of AIOS. He is past advisor and president of Telangana Ophthalmological Society and Hyderabad Ophthalmologist Association. He is co-chairman of Health Insurance and TPA Committee of AIOS. He has been member of Medical Legal and Ethics Committee of AIOS in past. He has been twice member of Managing Committee of AIOS, and he has also served as member of Advisory Board of IGO. So we have with us Dr. Prakash Marathe, sir, who will be talking to us. So he is consultant ophthalmologist at Netra Yogi Eye Clinic in Pune. He is past president of Maharashtra Ophthalmological Society, Pune Ophthalmological Society, and Indian Medical Association of Pune. He is member of Legal Affairs and Expert Group Committee of AIOS. He is chairman of Maharashtra chapter of ISMS-ICS. He is past managing committee member of AIOS. He is past senior vice president of IMA Maharashtra State. He is honorary secretary Social Security Scheme of IMA Maharashtra State. He has won various awards, to name a few. President's Appreciation Award by National IMA New Delhi, President's Appreciation Award by IMA Maharashtra State for the year 2013, 2014, 2018, 2020, and 2021. He is also won the President's Special Felicitation Award by IMA Maharashtra State for the year 2021 and POS late Dr. Asha Kelkar Award 2022 by Pune Ophthalmological Society. So over to you, Prakash Marathe, sir.
Hello. Good evening, everyone. I am thankful to YOSI for giving me this opportunity to present on the complicated issue of medical legal aspects. And I am very much thankful to my guide, mentor, senior ophthalmologist, who is a legal advisor at many institutes and associations all over the country, Dr. Anand Deshpande, sir. I think Ananta Deshpande sir has to be thanked for one more reason, that he is the person who has motivated me for various medical legal sessions, ICs on various platforms, national and state conferences. And for today's topic also, he has suggested me to talk on. Though I am not that medical legal expert as compared to him. Even Dr. Manish Matswe, who is my friend from Pune, though he's gynecologist, he is a very famous lawyer and young lawyer and helping so many people in Pune, Maharashtra and across the country for medical legal aspects. And young team of YOSI, not to forget them, Dr. R.P. Heda, Dr. Dipanshu, and many more who have been helping me with me for this particular series, even Kaushik Tripathi and everyone. They are the enthusiastic and young team across the country. Young ophthalmologists are being motivated by them. And I think this complicated topic of medical aspects is being discussed under that forum. That's very important. So coming to today's topic, I think court of law, there are so many issues. One of the important issue is civil and criminal liability. Basically, these two responsibilities are related to hospital and medical professional. And there is new criminal law. So in relation to that particular law, we are going to discuss. My presentation will be in two parts. First will be with a civil that I'll be starting. Thank you, Dr. Deshpande sir, for sharing me this presentation. Under your guidance, I have gone through all these slides. And if there are any lacunae, if there are any queries and questions, all of us are going to discuss under their chairmanship. Those panelists definitely will be helping all of us. So basically, civil liability is in relation to Consumer Protection Act 2019. This civil liability of Consumer Protection Act, next slide, please. Next slide. Yeah. So basically, in 2019, when this new Consumer Protection Act came, medical fraternity was very happy. They were pleased, and everywhere there was a news that medical profession is out of the CPA. But that was not the whole truth. It was a misunderstanding. Basically, there are various professions which were in that particular list, and there is one exclusion list. So basically, in exclusion list, that particular profession has to be there. When that news came, our profession, that is medical profession, was not there in the list where CPA is applicable. But our profession was not there in the list of exclusion where medical profession was written. It means medical profession is still under Consumer Protection Act. So this is the first misinterpretation which was there in the minds of various people, that medical profession is excluded from CPA. No, it is not like that. It is under CPA. So basically, service means service of any description which is made available to potential users and includes but not limited to the provision of facilities in connection with banking, financing, insurance, transport, processing, supply of electrical or other energy, telecom, boarding or lodging or both, housing construction, entertainment, amusement, or the purveying of news or other information, but does not include the rendering of any service free of charge or under a control of personal service. Next slide, please. So in the past, there were few jurisdictions like district, state, and national. So this was very simple and easy to understand. But basic change, what they suggested, in the past, it was up to 20 lakhs for district. For state, it was from 20 lakhs to 1 crore. And for national commission, it was different category. I think that slide is hidden, last part of that slide. What can we do? Yeah, no, first slide. Yeah. Karthik, can that last part be seen?
Sir, the slide is seen, isn't it?
Yeah, it is
Yeah,
visible.
it is completely visible.
National Commission is above rupees 10 crores.
No, but that is hidden in my particular.
Your presentation may be hidden, but we are able to see it.
Okay. Can it be seen? Aarti?
Yeah,
properly?
it is
Yes,
seen.
sir. Yes, sir. It is seen, sir.
Okay. No. Can it be little less magnified?
Sir, it won't be possible for me to like reduce the magnification. Otherwise, we will not be on the slideshow mode, sir.
Okay. You can make it the routine one, not slideshow. Go back. Because I'm not able to see the last part.
Okay. Sir, is it happening for every slide, sir?
Yeah.
I am unable to see the last part.
Yes.
Okay.
So don't make it slideshow. Only the magnified thing what Dr. Manish has suggested, 80%, like that will do. Yeah, now it's fine.
Yeah, it's good.
Now, for district, it was up to 12 lakhs, sorry, 20 lakhs. Then state commission, 20 lakhs to 1 crore. And for national commission, it was above 1 crore. Now, these were the figures in the past. So what happened with the next revision? The first important thing is, instead of up to 20 lakhs, it went to 1 crore, up to 1 crore. And that was a huge rise from government side. Only one thing which was little bit beneficial for our profession is the limit depends on the bill paid. I think that was the important. And most of the times our bill doesn't go beyond that. And for state commission from 20 lakhs to 1 crore, it went to 1 to 10 crores. And for national, it was above 1 crore, it went to above rupees 10 crores. Next slide, please. So as per new act, again, the right side is little bit hidden, Aarti. The limit is dependent on amount spent by the consumer, and that limit is 1 crore. So all cases in which patient has paid the bill less than 1 crore will be lodged a district commission. This is practically all cases will go to district commission. I think that way every case will not directly go to state or national. It can come directly to district, and that is the simple relief what medical profession may get. That's what you can think. Next slide, please.
Sir, is it okay for you now?
Yeah. Now it is fantastic. It is very nice for me.
Okay,
Now, about
fine.
the jurisdiction for lodging the case. In the past, in the area of cause of action, that is district, state or national consumer redressal commissions, area as per their limit. This was there in the past. But the worst thing, in the new law, at the cause of action or at the place of residence or workplace of consumer, that is patient. This is the worst thing. And again, one more option is given is online. So because of this, what has happened? Next slide, please. The patient can lodge a case at his residence or place of work. So the patient of Chennai taken treatment at Delhi can lodge a case in Chennai, and doctor has to run from Delhi to Chennai. This is the worst scenario. Again, he can lodge the case online and then doctor can answer online. This is the option available. But then when the patient is from Chennai and taking it to Delhi or Delhi to Kolkata or anywhere in the country, that is troublesome for the medical profession, for the doctor. But I think there is one provision where the case can be taken at the place of hospital owner or the doctor. But then in general, the patient can lodge complaint anywhere from the country where he stays or where the treatment is taken. All options are going from patient side. So that is the worst thing. Next slide, please. What was the old provision? There was a deposition of rupees 25,000. A limitation period for appeal was 30 days. And the new provision is deposition of 50% of ordered amount. This is very bad. So the liability has increased from the doctors and medical professionals side. So limitation period for appeal is gone from 30 days to 45 days. About appointment of judges also there is a difference. What is the old provision? The judges and staff was appointed by judiciary in the past. At least judiciary had some role to appoint the people. But what is the new provision? That is clause 29. The judges and staff will be appointed by central government. The qualifications and other details will be decided by central government. Next slide, please. The effect will be, what is the effect? The doctor may require to deposit a big sum, a big amount, if the district commission has ordered a heavy compensation. So that is the worst thing. Appointment of judges, the genuine judiciary judges may not be appointed, and then the decisions may be affected if the central government is appointing the other people. So judiciary's role was limited. Next slide, please. New biting teeth. If the complainant is not heard in 21 days, then it will be taken as admitted. Again, this is not from medical side. Next, clause 37(1)(2) and clause 74. After first hearing, the complainant will be referred to mediator. This is again the new thing which was added. That way it is good, that way it is bad. That these cases were referred to mediators, and there was consumer mediation cell. Now these mediators may be good, may not be good. Sometimes they may be beneficial to medical professionals, but they also can play the tricky role which can be troublesome to doctors and medical professionals. Next slide, please. So all the cases will be admitted and will be sent to mediation. Even our panelists will agree that putting this mediation is the double-edged weapon. Next slide, please. New clauses, again few of them. Clause 49(2) and 59(2). Any terms of contract which are unfair to consumer can be made null and void by state or national commission. See, contract was there for your benefit, but state or national commission has got the big role. They can make it null and void. That is bad thing for medical profession. Then clause 35(1)(2), product liability action may be brought by complainant for defective product that is serviced. Next slide, please. Clause 49(2) and 59(2). Any terms of contract, see there is a contract like consent, like MOU, which are unfair to consumer. See, they are deciding it is unfair to consumer, can be made null and void by state or national commission, which may be dangerous for medical profession, for doctors and hospitals. See, which is beneficial for us, which was there in MOU, is they are making it null and void. So that way it is going against to medical professionals. Then clause 35(1)(2). Up till now, negligence was the only cause for ordering the damages. But now, the services of any doctor or hospital may be labeled as defective and substandard, and damages may be ordered. See, in the past, it was just the negligence. But now it is not only negligence. Negligence will already be considered. But then few additional things like substandard service, if you are given, not related to medical profession directly, is also added. Next slide, please. So Central Consumer Protection Authority, to be known as Central Authority to regulate matters relating to violation of rights of consumers, unfair trade practices, and false or misleading advertisements, which are prejudicial to the interests of public and consumers, and to promote, protect, and enforce the rights of consumers. So clause 15, that is investigating authority. The central authority shall have an investigation wing headed by a director general for the purpose of conducting inquiry or investigation under this act as may be directed by the central authority. Next slide, please. So Central Consumer Protection Authority, Raj, will start. So what has happened because of this law? We had little relief to start with, that medical profession may not be coming under the CPA. But the worst thing, that Central Commission Protection Authority, Raj, has started by inspecting any hospital suo motu and lodging cases against them. So I think the scene is not that ideal. It is not that rosy, but it is troublesome for medical professionals. Next slide. I think we have covered the first part, that is about the civil responsibility. Now we will move to the second part, that is the criminal. Dr. Aarti, can you share the screen?
Yes, sir. Just a second.
Again, don't make it slideshow, the way it was magnified.
Sure, sir.
And all corners were easily seen.
So does this work for you now?
Yeah. Now you can imagine in a recent parliament session, Amit Shah, the central minister, has talked about medical profession, some exemptions, and medical fraternity was very, very happy. And about that criminal law, it had that particular background of 304, 304A. So this topic covers about criminal liability in medical profession in new criminal law passed by Assembly. Next slide. Yeah. If you remember 302, everybody knows, Dafa 302. There was movie. Murder, direct murder is Dafa 302. Now, in relation to that, there is 304. 304 is attempt to murder. But when that death occurs in medical treatment at the time of operation, in the hospital, in the ICU, that 304 is not 304, it is 304A. So this 304A means giving treatment to the patient, there is a death. Doctor has not tried any murder on that patient or death for that patient. But unfortunately, what was happening in our country, that most of the police, they were applying that 304 and not 304A. So what was the difference? One is bailable, other is non-bailable. 304A is bailable, 304 was non-bailable. And that way doctors and medical fraternity was harassed by police people. So when this particular law was discussed in the parliament, I think this topic is related to that. So current legal landscape, Indian Penal Code 1860, IPC, Code of Criminal Procedures 1973. Currently, again, Dr. Aarti, right side is little bit hidden. Currently, doctors and hospital can be held criminally liable under the IPC for various offences, including culpable homicide not amounting to murder. This is very important. That is section 304A, which was there in the past. Till today also it is there. I'll talk about it. Now it is 1061 of BNS 2023 applies if a doctor's negligence causes death. So instead of 304A, they want to put it 1061. Then the Rash or Negligent Act Endangering Human Life section 336, now 1222 of BNS 2023, with provisions of exception 1 and 5 of clause 101. This applies if a doctor's action put someone's life at risk. So hurt by endangering life or personal safety of others, section 337. Now 125 of BNS 2023. This applies if a doctor's negligence causes physical harm. Criminal medical negligence. So it was section 304A of the IPC as amended by Medical Negligence Act 2009. This specifically addresses medical negligence leading to death with stricter penalties than section 304A. Next slide, please. Again, Aarti, you have to see that slide is not hidden. So new law of criminal procedure code is called as Bharatiya Nagrik Suraksha Sanhita. So what is that BNS? It is Bharatiya Nagrik Suraksha Sanhita 2023, 46 of 2023, repealing the Code of Criminal Procedure 1973, 2 of 1974, proposed changes in it. Streamlined procedures. This law focuses on streamlining criminal investigation and prosecution procedures. Increased powers for police and magistrates. The law proposes giving the police and magistrates more powers, which could impact how medical negligence cases can be handled. It's crucial to remember that these are just proposed changes. After repealing the old law, and the final versions of the laws might differ. Again, it is not completely passed. So it is in between. The stage is in between. Next slide, please.
Sir, is it seen now?
Yes, yes. Yeah, it is seen.
Thanks.
Then, repealing the Indian Penal Code 45 of 1860, proposed changes, exclusion of doctors from criminal prosecution. This is very important. The proposed law reportedly excludes doctors from criminal prosecution for death caused by medical negligence. This has been a controversial provision which concerns about accountability and patient safety. That's what they feel. So focus on civil compensation. The new law might emphasize civil compensation for medical negligence instead of criminal punishment. Next slide, please. So this particular law, which was being discussed in the parliament, they are yet to get in effect. They were introduced in Lok Sabha, Indian lower house of parliament in August 2023 and are under review by the Standing Committee on Home Affairs. Means it is not into law. Standing Committee will study about it and they will finalize if there are any changes, they will suggest the changes, if there are any additions, deletions, modifications, and then only it can come again and the law may be formulated. So amended Bharatiya Nyaya Second Sanhita Bill 2023 passed since, however, did not provide that blanket exemption to doctors, what we are feeling, not blanket exemption to doctors. Instead, the amended section 1061 specifies that a registered medical practitioner, that is RMP, shall be punished with imprisonment of 2 years and a fine. Probably our experts will be able to tell about this. Next slide, please. So on that Friday, 22nd December 2023, the Indian Medical Association, that is our topmost body, IMA headquarters from Delhi, the largest organization of the country representing doctors in the country, extended its gratitude to Prime Minister Narendra Modi ji and Indian Home Minister Amit Shah ji via a daily newspaper advertisement, that was very important, for exempting medical professionals from criminal prosecution under 304A of the IPC, now 26 of BNS, Death by Rash or Negligent Act. Next slide, please. So the Union Home Minister said that the amendments were introduced after the Indian Medical Association requested us to look into the matter, and hence we have decided to free the doctors from the culpability of criminal negligence. The gesture followed Minister Amit Shah's announcement in Parliament on that Wednesday, while the 3 criminal reform bills were passed, assuring that the provisions related to death resulting from medical negligence would be excluded from Section 26 of the new bill, that is Bharatiya Nyaya Sanhita, that is BNS. In essence, the government has declared in principle its acceptance of the IMA's plea that there is no criminality involved in the relationship between doctor and a patient. Next slide, please. So that deals with causing death by negligence, which makes a differentiation between a doctor and any other person causing death. See, it is the other type of death at doctor's place by doing any rash or negligent act not amounting to culpable homicide. Next slide, please. So Union Home Minister Mr. Amit Shah ji informed Lok Sabha on that Wednesday that the amended criminal law bill would provide immunity to medical professionals. This is very important. Immunity to medical professionals from criminal prosecution in instances of deaths due to medical negligence. I think that is the worst part in our medical practice. In unfortunate situations, there are deaths occurring, but medical fraternity, doctors and hospitals, they are at risk because of that old law. So the bill passed in Lok Sabha on that Wednesday after a voice vote in the absence of 97 opposition MPs who have been suspended for misconduct for the remainder of the winter session. So that way, the particular bill is the hope for medical fraternity, hospitals and doctors. Next slide, please. So thank you so much. I have tried to, you can unshare Dr. Aarti. You can, so thank you, all of you. Thank you so much, Dr. Anand Deshpande sir, for providing me these slides. And I have tried from my side to elaborate on civil and criminal responsibility in relation to medical profession, doctors and hospitals, and the relation to this with that criminal law. So over to you, the organizers and panelists. Thank you. Thank you so much for the opportunity.
Thank you very much, sir. It was a very enlightening talk. And now I would like to invite our panelist, Dr. Anand Deshpande sir, to please give his comments on the topic.
Yeah, as Dr. Marathe has nicely told everything about the criminal and civil law, the Consumer Protection Act 19. That is now it is applicable and it is being used and it is known to everybody. There is not much confusion in that. But in criminal law, definitely there are so many confusions to the doctors, to the advocates, to the judges, and to the police also at present. because it is not that ambiguous, but it is yet to be ordered. That is, the law is passed, but it is not in ordinance. So it is not applicable at present. So everything is going on as per the old law at present. But in future, definitely it will come. The base of this criminal procedure code, that is a criminal law change, was that there was a big pleading from the IMA to the government, to the Modi, to the Shah, and all that. The doctors are not the criminals, really. For causing the death, there should be, as per law, there should be mens ira. Mens ira means intention to kill. And if that intention is not there, the person is not a criminal. If anything happens without any intention to do the crime, it is not a crime at all. So, taking into the benefit of that mens ira, the law is being changed or tried to be changed to the extent that as said in 26 BNS, it is clearly said that, I will read the law actually. The act not intended to cause death done by a consent in good faith for person's benefit. So there are two things are there. One is for person's benefit, and it is with the consent of the person. Nothing which is not intended to cause death is an offense by means of any harm which it may cause or be intended by the order to cause or to know by the doer to be likely to cause to any person for whose benefit it is done in good faith, with who has given a consent, whether expressed or implied. This is also very important, whether expressed or implied. Implied means whenever the patient comes to you and attends you, accepts everything, gets ready for operation, that is implied consent. Implied to suffer that harm or to take the risk of that harm. So this law, though the actually 304A, which is converted into 106A, there is not a clear-cut protection, but in 26 BNS, that is BNS means the Bharatiya Nyaya Sanhita 2023. It is clearly shown that if there is no intention and with good faith, with the consent of the person and for the benefit of the person, if the act is done and it converts to death, it is not a crime. And everybody knows it. What was happening? Why this decision was taken? It has a good reasoning behind it. When this came, the doctors started to not treat the patient who are serious. They were just avoiding. Hospitals were also avoiding the deaths in their hospital. They were just transferring the patient to one hospital to another and lastly to the government, so that the thing will happen. So this avoiding, transferring caused many deaths of the patients unnecessarily. And this is the impact which has happened because of this law on a common person, common patient, which was required to be changed. And now this is being changed. So though 106 is going to be 2 years punishment at present, but 26 gives clear indication that if there is a consent and for the benefit of the patient person, you are doing the work, may the death happen, the doctor will not be held responsible. This is the main thing, which is a very important change in the criminal law. Remaining laws are there, which Dr. Marathe has cleared very much, and I think everybody must have understood it also. If any problem is there or any queries is there, I am there to answer. Yes,
Thank you very much, sir. Sir Manish, sir, would you like to comment on the topic?
Okay. So few things I'll clarify. Very nicely done, Marathe sir, and of course Deshpande sir is the big boss, the big B Amitabh Bachchan from ophthalmology with respect to medical legal.
Thank you, sir.
Okay.
Thank you.
So there we have to understand few things. There are different fora under which a patient can complain against a doctor or a hospital. Now, what are these fora? One of them forum is consumer fora because it is governed by Consumer Protection Act. What does consumer fora decide? It decides about deficiency of service or unfair trade practices. And what is the result? Either the doctor is exonerated or the doctor has to pay compensation. Second is civil code. What does civil code decide? The civil code decide whether there was infringement of right of the patient and with respect to negligence. So what is the output of civil court or civil case? Either the doctor is exonerated or he has to pay compensation. Third is criminal courts. So where the police investigate a complaint against a doctor and then file a sheet of evidence called charge sheet. And then the trial begins in the court. Now, for police to investigate a criminal complaint made by relatives against a doctor, there are standard guidelines which the Supreme Court has given in the landmark case of Jacob Matthews versus State of Punjab. So what the police are supposed to do? The police are supposed to write down the complaint, take the deposition from the doctor, take the Xerox copy of case papers, collect the post-mortem report, and then take opinion, expert opinion from a committee which is either under the civil surgeon or government medical college. Now, if that committee says that there is gross negligence, only then the police will register an FIR. And FIR, as on today, is registered under Section 304A IPC, which is death caused due to rash and negligent act. It is a cognizable offense, so doctor is arrested, but is a bailable offense, so doctor gets bail as a right and goes home. And once the case starts, then there is question of witnesses, defenses, etc. So this is forum number 3. What is forum number 4 is disciplinary committee of Indian Medical Association or Maharashtra Medical Council. Now, what do these committee look into? They look into professional misconduct. What is the output from these committees? So IMA can suspend or cancel the membership, or MMC can remove the name of the person temporarily or permanently from the Medical Council of India register. Another one is State Human Rights Commission and National Human Rights Commission. Herein, mostly the hospitals which are run by government or semi-government organizations or NGOs, they can complain against these hospitals or personnel working them can be done at this National and State Human Rights Commission. And the last one is Lok Adalat, which is also there. In Lok Adalat, you can complain directly, or somebody who has a court case running can, other than criminal case, then they can go to Lok Adalat and try and get a consent decree, which means a sort of mediation where both the doctor and the patient decide at a certain point what compensation, what things are to be done, and then the court will pass a decree, the Lok Adalat. So what I'm trying to tell you is there are different fora which decide about different things. So, for example, negligence is only decided by civil and criminal courts. Professional misconduct by IMA, MMC. Lok Adalat will always have a mediation and give an award which is acceptable to both the parties, sort of a consent decree. And Consumer Protection Act will discuss about deficiency in service and unfair trade practice. Two major differences between civil liability and criminal liability is a crime is always against the state, which means if there is a criminal case, the criminal case on behalf of the patient is fought by a public prosecutor. Crime is always against the state. So the case, if you read the case law, it will read, for example, Dr. ABC versus the state or state versus Dr. XYZ. There, the crime is against the state, whereas the civil liability, the liability is against an individual. So you have two advocates, one advocate from the patient side, one advocate from the doctor's side, and they will fight either a civil case or a consumer case. Now, how is negligence decided? So negligence rests on three very important things. First is whether there was a duty to take care between the patient and the doctor, which means is the doctor-patient contract established, which is established for our practice always. But in case of a doctor who's examining a patient who has come for example, for insurance, then the doctor-patient contract is not established. So duty to take care, establishment of doctor-patient contract is one. Second is, was there a breach in the duty, which means that the standard protocols were not followed, act of commission or omission, or the competency of doctor is not there. And third is consequential damage. So on these three pillars, the negligence, civil negligence rests. Even criminal negligence would rest on these three pillars, but in criminal negligence, they would use sections of IPC because the punishment is according to what section is put on the doctor. So overall, we have to understand these differences. And with respect to criminal negligence, we have to also understand, as Deshpande sir very correctly pointed out, no doctor can be held responsible for a murder of a patient because what you require is the guilty mind. It's called mens rea. And guilty mind for the doctor is never there because it is never in the intention of any doctor giving any treatment to any patient that the patient would die. So fastening a criminal liability against a doctor is not that easy. आपण घाबरतो पोलिसला, but it is not so easy to fasten a criminal liability, but there's so many things which come into play. So this is something which we have to note now. One more thing, I'll go one step ahead and I'll also tell you that is there is civil liabilities for hospitals also. Crime is always done by an individual. So, for example, an XYZ hospital cannot be a criminal, but a doctor can be a criminal, right? So, civil liability can be put against hospitals. For example, deficiency in service can be put as a complaint where oxygen cylinder was not available, drugs were not available, expert doctors were not made available. So, all those things. So, even the healthcare institutions will have civil liability, whereas the criminal liability is fastened only against an individual. I think this is the basis which I wanted to just discuss. So this is something which we all should know. Also read some landmark judgments. Maybe once we'll do on landmark judgments, Deshpande sir will be very happy to discuss all those cases. For example, the case which I told you just now, all the guidelines of investigation of criminal complaint against doctors or professionals have come from Jacob Matthews case. Then there is Prabha Manchanda case with respect to consent. So there are so many landmark cases which keep on coming. So maybe once we will have it on landmark case. So thank you very much. I think very well covered by Marathe sir. He really went into details of Consumer Protection Act and criminal liability against doctors. A lot of sections can be put against doctors, hurt, grievous hurt. So a lot of sections can be put. And of course, we have to also remember, I did not start by talking on this because this is an ophthalmology forum. In the evening, I had a panel discussion, Indian College of Obstetric Gynec. Large number of people attended that, which was on MTP. So we have to also understand other acts, which Deshpande sir also said that there are other acts like MTP Act, Bombay Nursing Home Registration Act, PCPNDT Act. So there are other acts also where, for example, PCPNDT or MTP, criminal liability as well as civil liability can be fastened against a doctor. So we have to be careful with respect to those acts also. Lastly, one more thing which I will tell you all since we are discussing criminal liability and issues is once the Criminal Amendment Act came after the Nirbhaya case in 2013, examination of sexual assault victim and giving treatment to sexual assault victim is compulsory for all RMPs. So even if you are an ophthalmologist, you have to give primary treatment to the sexual assault victim as an emergency without charging. Point number one. Point number two, if you are a lady RMP, Aarti, this is for you. You cannot say that I will not do a medico-legal examination of a sexual assault victim brought to you just because you are a private practitioner and ophthalmologist, because the criminal law clearly says, CRPC clearly says that it has to be done by a lady registered medical practitioner, which you are. So if there is no lady registered medical practitioner, then a male RMP can also do it, either in the presence of a female RMP or a attendant. So please be aware of this. And if the police get a sexual assault victim to you, you cannot refuse every time and say, let the case go to Sassoon or government institutions. So this is something which we have to remember. All of you have to remember. So thank you. I think in short, this is what overall I thought everyone would understand about civil criminal liability and number of fora. The last point is there are some 7 fora under which the patient can complain against a doctor, and all the fora can be approached at one go, which means that if a criminal case is going on and a civil suit is put in civil court or a consumer suit is put in consumer court, there cannot be a defense in the court that the criminal case is already going on. You can have all 7 fora activated together. So thank you so much. Thank you for allowing me to speak and tell you a few important things. Thank you, sir.
Thank you very much, sir. And that was very enlightening for us to understand all those details. I had one doubt in sir's first presentation. Sir had mentioned that whenever in the new law, if the lawsuit which has been filed against the doctor, if it goes from the lower court to the higher court, still the doctor has to pay like 50% of the compensation amount, whatever he has been fined. So if the doctor has been fined, say 50 lakhs, so does he have to pay like 25 lakhs for it, or how is it?
No, he has not to pay. He has to deposit in the court for going in appeal. 50% of the ordered amount should be deposited in the court as a court revenue, not as a revenue, but as a deposit. If you win the case,
That will be
the
refunded.
25 that amount will be reimbursed to your doctor. If you lose the case, the remaining amount, whatever the higher court orders, doctor has to pay, and that previous amount will be calculated in that, in total
And
amount.
it is with interest or without interest, sir, in that case?
It is without interest. Wherever it is deposited in the court, court doesn't give any interest.
Kaushik sir, Aarti ma'am, would you like to ask?
My one more take home, which I always tell in all medical legal talks, is don't get fearful, or don't be afraid, and don't get saddened, and don't get depression because there's a case or somebody has complained. It's a long way before any type of negligence can be proved against a doctor. So do not get disheartened. These things are going to happen. So initially people used to say that if somebody says ki I don't have any complications, means either that person is not operating or lying. So if you are not having a dissatisfied patient, there's always going to be a dissatisfied patient in your practice. So if you do not have one, which means either you are not practicing or you are lying. So same holds true here. Sometimes or the other, some things go wrong. Also, a lot of places when I go and people, we do these panel discussions, even when there are lawyers, etc., or for common people. One thing which I categorically tell everybody, that don't you all start calling doctors, doctor, you are God, doctor, Dev hai, ye band kar do. Because that is the mentality because of which they think कि ये भगवान है तो ये गलती नहीं कर सकता, या कुछ ये जिसको भी हाथ लगाएगा उसका सोना हो जाएगा. ऐसे नहीं होता है, because 2+2 is never 4 in medicine. Doctors are not God. And even if we do best of services, give best of services and best of treatment, it doesn't mean that the patient will have best of recovery. So this is something which we have to keep in mind and keep on bombarding this in front of all our patients and common persons. If we have to improve our image in society, we only have to do it ourselves. Nobody else is going to come and do it for us. So this is something which you should practice.
Yes, what Dr. Manish Mathur has said is exactly correct. And on this basis, Supreme Court has given a decision also. Whatever treatment is given by the doctor is not challenged, or it is not said that it is not correct. Another thing is that whatever treatment is given by the doctor, whether it gives relief or it increases or it causes the death, the doctor is not taken as a cause of that. He has done it with a good intention, so he cannot be said that he has done the wrong. So that provisions are also there in Supreme Court decisions, and so doctor is never blamed. The Supreme Court also understood that the results can be anything. Whatever is routine, whatever is as per the treatment is given as per the books or the journals, and then he is right, and he has not done any negligence. Which type of treatment he should give, that is not never dictated by any court or any law. Another thing I would like to add, that whenever a case dies, the police previously used to arrest the doctor, but there is a Supreme Court decision in that. Now they cannot arrest the doctor directly. They have to produce first the reasons for arresting to the medical board or a panel of civil surgeon and body, and give the reasons why the doctor is to be arrested, and why the doctor is not giving the support, or he is disturbing the evidences or that. And if that is proved, then the permission can be given by the court to arrest. Otherwise, they cannot arrest the doctor. The court doesn't give an order, but the suggestion is there from the medical board or a medical person that it is worth arresting the doctor, and then only they can arrest immediately, because FIR is formed or there is a cognizable offense. They cannot arrest the doctor. That protection is always there with the Supreme Court decision.
So I think the session was very informative and let's say a little scary as well. But I just want to bring up this point that when we were doing MBBS, let's say 15 years back, I at least was not aware of so many things, and so many new things have come up in last few years. So as Manish sir rightly said that, though I'm an ophthalmologist, I can't say no if a sexual assault female patient is in front of me. So how can one be updated about all these things? Um, is there a need for the syllabus to be changed, or some things included when you are MBBS student, or let's say if in case whichever subspecialty you are, or should there be any compulsion that you should do some course related to medical legal for you to have the registration with MMC or MCI? Because otherwise I would have never known these facts if I would not have attended this session.
No, I'll tell you,
Yeah.
because I have a daughter who's pursuing MBBS now. Syllabus has changed. So whatever is being taught to them, lot of things have changed. For example, right in the first year, they have a course of 8Com, that is communication skills. So they are taught communication skills, they are taught presenting skills, they are taught oratory skills, they are taught how to break the bad news, how to face a mob. So everything is taught right at the beginning in first year. Then when you go to second, third year, your forensic medicine. So I mean, I know at her age, she's very unhappy in doing all those things. But they are taught how to write medical legal certificates, how to write rape victim examination findings, so detail, and they have to. There is a theory and a practical paper on it also. So it's not that they can put it for option. So now the MBBS curriculum has it, and these young students are learning. What is to be done about people like us who have passed out and gone out is something which you can always do. Have these programs. That is why we are having such good webinars. Or especially with respect to sexual victim examination, I feel irrespective of your post graduation, in one of your major conferences, please keep a 2-hour session on sexual victim examination. I'll tell you, or we'll have a team. They'll tell you from where to procure what and what is to be done, because it is very essential. You cannot say no. You say no, and the police is somebody who doesn't like you and goes and complains to a magistrate, then we have a problem. So, these are small things. But of course, learning through webinars, having these events and conferences work. But for the newer kids, it is definitely there in their syllabus.
Yeah,
And the
I will
credit,
add to Dr.
sorry.
Manish Machwe that basically we are MBBS, and after that we are postgraduates in particular field. So
Correct.
when we are doing the postgraduation in particular field, suppose ophthalmology, we are not supposed to forget the knowledge of MBBS. And that knowledge we have to keep throughout our life and use it whenever it is required. And that knowledge of jurisprudence and toxicology, that gives everything which is required for a basic practitioner to do in emergency. Fortunately, nowadays, where the ophthalmologist is practicing, naturally, there in government hospitals, there will be a lady doctor of any branch. And so the patient will not come to a private. But if it comes, you have to examine. There is no other way. That's true.
Just to add from my side, I think for the youngsters, those are going into that seniority phase, and even seniors, they are not going to make it in their medical college days again. But then what MMC registration in the past, well, there were some norms that upgrading your knowledge, some credit points, some credit hours from CMEs and conferences you have to gather. And there was some proportion which was advised by Maharashtra Medical Council that few of them must be from Medicolegal. So that particular Medicolegal CME or Medicolegal sessions in your conferences, those were must. I think YOSI has been doing this wonderful job of this medical legal series. You yourself are beneficiaries of this particular webinar. Not only you people, but all YOSI members across the country. Even other people, those who are attending such webinars, are getting benefited. And again, these webinars are recorded, they are available on YouTube. So the person who cannot attend this program today, and the program is available for him afterwards, can watch this on YouTube or other platforms. So this particular webinar series done by YOSI, I must congratulate. And everybody must attend CMEs, conferences, and all other specialty people also have this medical legal session, as Dr. Manish has rightly said, that some CME, some conference, all those things, they must include their knowledge, their scientific program, but medical legal must be there. And nowadays, what I have observed that in all our upcoming conferences, national, state conferences, even CMEs, there are medical legal sessions. And we people are being invited, Dr. Machwe sir, Dr. Deshpande sir, Dr. Naurangi sir, myself, and people like you. Even I have attended conference of YOSI, and even in your YOSI sessions, I think we have done that medical legal sessions, and people are eager to attend. I have seen two types of people are attending that medical legal sessions. Those are interested in gaining that knowledge of medical legal, or those who are in trouble. That's very important. Once they are in trouble, they attend those sessions and they ask their private, direct related questions at the time of medical legal seminars and that particular sessions, as if they want to solve their problems, whatever it may be. But I think everybody is trying to take that knowledge of medical legal nowadays.
It becomes an open forum for them to ask freely, sir. I think.
Yes, that's
Dr. Kaushik, anything from your side?
I just wanted to know whether if something criminal, like can police or is this the, are we actually exempt from this thing that
See, so I'll tell you how, Kaushik, 3-4 steps I'll tell you. Step number 1, there is a lot of applications being put, a need generated, somebody puts a PIL. So government thinks that either they have to amend the act or take out new act. Then the second question comes, would it be a state act or a central act? If it is state act, the state legislature, and if it is a central act, the central legislator would sit on it and try and get all the things together, get opinions from organizations, so get opinions from AIOS, MOS, etc. Then they have a law department which would actually sit and frame it. Then it goes to the standing committee. From there, it will go to the parliament. So both the houses of parliament, state legislature or central legislature. If it is passed, it is corrected. Then it goes for the assent of the president or governor, depending on whether it is a state act or a central act. Once the governor or president signs or gives the assent, then the act is published. Then the bill, till that time you call it a bill. Then the bill is published in either the state gazette or the central gazette. And when it is published in the gazette, that publication in the gazette gives a date from which it is going to be functional. If no date is given, then on the date on which it is published in the central or state gazette, it becomes functional. So just now it is whatever discussions are happening, they are only discussions. They have only reached to a point of bill. It has not got assent of president. It is not published. So till the time it doesn't get published, we still follow the old.
hope so. There will be the fruitful outcome, because people are thinking that maybe election gimmick and it may or may not be passed. It is just the positivity they are trying to show, but hopefully it will be done, because it is the positive intent even from the government side that the law is must, and hopefully it should be done. Only the thing is, it is under process, not yet passed. So, Dr. Manish, up till now, though it is not passed, as it is not passed, probably 304 is functional, right?
Yes, absolutely. I
Ma'am, do
think
we
if
have
you
any
look
other
at
question?
if you look at Dr. Kaushik, I think he needs a holiday. He's been working very hard. He's sleepy and he's working very hard. I think Friday, Saturday, Sunday, take a holiday, boss, go out. महाबळेश्वर चले जाओ.
Sir, we have been telling this to him quite some time now. He's not
So I
following.
was correct. No, I can see a person's face and
Very
tell
much.
he
He came
needs
back
a
from
break
hospital at
desperately.
8:30 only, sir.
Yeah, he needs a break desperately. Break from profession, break from wife, from everyone.
Break from MLC also, sir. From us. All right. If we don't have any other questions, can we close the session?
Sure,
Yes.
sure.
So I would like to thank our esteemed panelists, Dr. Anand Deshpande sir and Manish Machme sir. Dr. Mathur sir could not join since he is in Bali. And also, I would like to thank especially Dr. Prakash Marathe sir for taking out time and speaking on this very important topic, one of the recent topics since it was highlighted in the from the government side as well. Hopefully, we will continue to keep organizing these webinars and cover more important topics in the coming future. And hopefully, we will have all of you with us in the future sessions as well. So, thank you, everyone. Thank you, Aarti ma'am and Kaushik sir. We'll connect probably in the next session in the month of March or April, according to our schedule. Thank you very much.
Okay. Thank you. Good
Thank
night.
you.
Good night.
Good night, everyone. Good night.
Thank you,
Thank you so much.
everyone.
Thank you.